Philippines has one of the biggest number of qualified workers, with 59% of the total population employed. 52.1% are in the services field, while 33.4% are in agriculture and 14.5% in the industry field as of the 2014 report by the Philippine Statistics Office. With so many people working and providing services to the country, the rights of all working Filipinos cannot be ignored. And this is where the Labor Code of the Philippines comes in. The Labor Code stands as a law governing employment practices and labor relations in the Philippines. It prescribes the rules for the hiring and termination of employees, the conditions of work, including the number of work hours and overtime. It also includes the benefits each employee can enjoy, such as holiday pay, 13th-month pay, and retirement pay. It also provides a set of guidelines for the organization and membership of labor unions and the right to be recognized. What does the Labor Code cover, and how does it protect the Filipino employee? What rights and benefits are entitled to them? If these rights and benefits were ignored, where can workers go to file a report?
Good evening. You are watching Legal Help Desk on 9TV. This show is about making the law work for you by giving legal advice on topics that matter to you. I'm Attorney Karen Jimeno.
And I'm Attorney Nepomuceno. Tonight, we will discuss your legal rights as employees according to the Labor Code of the Philippines, what you need to know about the rights and benefits you're entitled to, and what you need to do should your rights be violated as an employee.
Our guests for tonight are Dave Diwa, President of the National Labor Union, and Attorney Sonny Matula, President of the Federation of Free Workers.
Yeah.
Good evening, and
Good
thank
evening,
you for being
Dave.
with us, gentlemen.
Attorney Sonny?
Good evening. Thank you.
Welcome back. Yeah. Okay, we'll start
the
with
topic of benefits. So it's a
Yeah.
very interesting and of course relevant topic, because when you say yes, you're not just expecting to get salaries normally. You also say yes to a job because of the benefits that you'll get in return.
Right. So let's focus. I know the labor code's kind of wide. So let's focus in regard to employees' rights today. Let's focus on employee benefits. So if I was an employer, or let's say I want to start my own business, what's the first thing I need to know, or checklist, if you will? Ano yung checklist ko na I need to give to my employees? As a basic
Now, of course,
lawyer first.
the number one is the wages to
wages, of
be
course.
given to the workers. And now we are...
The minimum wage.
Yeah,
Can
the
we
minimum
talk about
wage
that?
What is the
required
minimum
by
wage
law.
now?
Oh, of course that you can give above the minimum, but the minimum is the threshold standard. So there are a number of minimum wages all over the country. In the National Capital Region, we have 466 pesos. So
That should be net?
no,
or
that's
gross?
the minimum wage, the gross minimum wage.
Gross minimum
to be
wage,
given
inclusive
to
of the
workers.
taxes.
Yes, yes.
Okay, so 466 per day.
466 pesos per day in the National Capital Region. And the other regions there, we have different minimum wages according to the orders issued by the different regional tripartite wages and productivity boards.
Now, since it's a per day thing, is there a minimum number of days you need to employ the person? For example, can you do 466 per day, pero you're employing them, let's say, only Monday to Thursday? Is that possible? Or meron bang minimum per month?
The labor code does not provide any number of days, but of course it is understood that when you give the workers a job to work, then it is understood that it's a minimum of 8 hours a day and about at least 40 hours a week.
Okay, so at least five working days.
5 working days.
Five working days, yeah.
All right.
And then what about
I'd like, but your opening statement talks about the rights of workers, how they can be protected, and what they will do if there are any violations. In terms of benefits, there will be about anywhere from basic benefits, they call it labor standards, anywhere from 15 basic benefits that should be given to the workers to about 25. So that's a lot.
50 to
Now,
25.
talk of violations, unfortunately, as a general rule, only a few of these statutory benefits are being granted by the employers, and most of the rest are not
disregarded.
For instance, you talk about the work number of the work hours. The law says that a worker should be guaranteed an 8-hour work per day, 40 hours a week. But as Attorney Matula said, there are certain companies that would require their employees to work only for 2-3 days, and unfortunately, that's allowed under the law.
And pay them the
Pay them
466
for 6 days.
Okay.
But
Also,
some employees usually are contracted to just render service
Precisely
for
Specific
sasabihin
days.
nila 15 days only per month or
Precisely.
every other day.
Yeah.
So if you are someone that is being offered that type of position, should you negotiate for a whole month's pay even if you only render
let's say,
3
Yeah.
work days per week?
It can be negotiated, I think. Yeah? If you work only for 3 days,
days
a week and you
yeah.
are given, and then you work for the 4 weeks in a month, and then you are given, for example, 10,000 pesos a month or 15,000 pesos a month, it can be
negotiated.
negotiated by the parties.
But,
Okay, but can you be forced to just stick to a 3-day work week and be paid only 3 work days per week?
My understanding is that if that is the work that is required by the company, and
Then
you
it's
agree,
possible.
then you cannot be paid more than that
So
because
it's really contractual.
it's some sort of a fair wage for a fair work.
So, every case is different. So if let's say this reaches let's say a labor arbiter or whatever, it will have to the arbiter will have to decide based on the circumstances.
Yeah, it's
as a whole.
actually it's a question. It's a factual question
Yeah,
that should
more
be
whether it's fair or not.
Yeah.
that should be balanced by the judge who.
Yeah.
And this
present
is different, Mr. Diwa. For instance, if you were hired at the start to render 5 work days per week, and then later on, the employer says, because of business losses, we're cutting your work days into just 3 times per week.
That's possible, but you have to seek the permission of the Department of Labor. There are certain programs at the department that would allow the company to do that. There is the so-called compressed work week.
So,
As you said,
the requirements, and it needs the consultation and the consent of
the workers
the
themselves.
workers.
how do they
Hindi
go about
pwedeng
applying for that?
unilateral.
How does the employer go about applying for that? Do they
There's a
just
prescribed form, they fill it up, tell the
with a dole?
DOL, the regional office where you're-
Inform the dolly, and the primary consideration is the workers must give their consent, and that is only for a temporary period.
Oh, in relation to that, because let's talk about how an employee becomes a permanent employee, because usually that's based on time. What is the period now where an employee has been rendering service where he's then considered a permanent
regular
employee?
employee.
If you take up Article 280 of the Labor Code, when the work is necessary and desirable to the usual business of the company, on the first day of work, he can be considered as a regular worker.
First day
For
pa lang.
instance, if your business is a department store and you hire someone to be a sales lady, then that should be considered
if there is
hiring
no
someone as a
agreement that
regular.
that is a necessary and desirable to the usual business of the company, then you can be considered as a regular worker. But usually, the employer adopts a probationary period of at least 6 months.
6 months.
So if you're beyond 6 months and then the work you perform is necessary and desirable, meaning it's really in accordance with the nature of the business of the employer, then you should be considered a regular employee. For instance, if they say, oh, you're still probationary after 10 months, that's already a violation.
I understand that's already a violation of the provisions of the Labor Code.
So you cannot be a probationary employee forever.
But even if it's not necessary and desirable to the usual business of the company, Article 280 speaks also of if you work for 1 year, either continuous or what you call that one?
Uninterrupted.
Uninterrupted, or there is some interruption, but the total period
Period
is
of
1
work.
year, you can be considered also as a
Regular.
regular worker.
Okay.
Okay, now we go back to benefits. We already talked about wages as one of the, of course, obvious primary benefits, and we have to have the standard, meaning the minimum wage at least. What about other benefits? I've seen some payrolls, the pay slip, which would indicate rice allowance, transportation allowance, even laundry allowance. So
Yeah.
what allowances are really mandatory that you have to demand from your employer?
Yung mga
Okay.
required by law.
You require talaga by law.
This transportation and laundry, probably you can get that from the collective bargaining agreement or from the policy of the company.
So as an employer, it's not mandatory.
It's not
naman.
mandatory. But
Ano po yung,
what
ano po yung
are the-
mandatory? Yung talagang required.
Yeah,
Meaning,
that's obligatory on the part of the employer to give to his employees.
Yes. For instance, Mr. Diwa, what I think he's ready to
The law will
enumerate.
require that you pay your employee in terms of wages, the basic wage of course, if it's
basic
minimum,
wage, yeah.
minimum. Then the statutory benefits that you should have from the SSS,
SSS, okay.
PhilHealth, Pag-ibig,
Contributions, yeah.
and some others in terms of
The amounts of that would be dependent on the,
your
the
bracket, in your
bracket,
in your
salary
salary.
scale.
Because
Okay.
for every salary, there is a corresponding bracket and
Okay.
contribution they have to pay. Then the 13-month pay, it's obligatory.
Okay.
13-month
So,
pay.
December now, so it should not be...
Malapit na
The
December.
The
so
5-day service incentive leave. It's
5 days,
if you have rendered more than one year of service, you're allowed to have. The company is enjoined, in fact mandated by law to provide a 5-day incentive leave. What else?
The holiday.
The holiday.
Of course, the holiday pays, premium pays for holiday for work rendered on holidays. No? So that's mainly.
Those are the main benefits. Okay. All right.
Well, I'll ask our guests more about other types of benefits, including vacation leave,
Yan.
sick leaves, maternity benefits.
Okay.
But for now, we'll have to take a short break. Legal Help Desk will return after these messages.
With the rise of contractual and freelancing works in the job market today, many are not aware that the rights and benefits of contractual and freelance workers are different from those of full-time regular employees. For full-time employees, there are actually 6 basic benefits that are entitled to them. Wage and wage benefits, including overtime, night differential, holiday, 13th month, and retirement pays. SSS, PhilHealth, and Pag-ibig coverage, leaves including service incentive leaves, maternity leave, solo parents leave, paternity leave, leaves under the Magna Carta of Women, leaves under the Anti-Violence Against Women and Their Children's Act. Freelancers must understand that under the Labor Code, they are considered self-employed. They can, however, opt to enroll themselves to SSS, PhilHealth, and HDMF as self-employed individuals to avail of the benefits these institutions offer. To know more about the Labor Code, you can go to the website of the Department of Labor and Employment for review.
You're still watching Legal Help Desk on 9TV with our guests, Dave Diwa and Attorney Sonny Matula.
Okay, so right before the break, we were discussing yung benefits, more particularly yung wages, and then you enumerated, Mr. Diwa, yung pag-ibig, yung pag-ibig contributions, PhilHealth,
Yes.
SSS, all right, and you mentioned that there should be, separate from those would be a 5-day incentive leave once they reach 1 year.
Rendered service.
Sige.
But I guess since you enumerated yung mga mandatory benefits, we have to distinguish between yung mga tinatawag nating regular employees from those that are only contractual or probationary or on a project basis, because are these mandatory benefits also available to these types of employees?
That's precisely the problem. No? That's why we have this phenomenon of 5-5-5. Workers only hired for 5 months because Once he gets to be a regular employee, he must enjoy all the
All the
benefits that you
benefits
enumerated.
that, so
When you say 555, yun may mga 5, you only hire them for 5 months.
And
Oh,
then,
para hindi umabot ng
6
6
months,
months, tapos hindi na sila probationary,
regular.
magiging regular
Correct.
employee na.
Ganon.
Okay.
So that's the scheme, no? Kaya no? Then what else?
So if you're someone that is being hired by, for instance, a certain company, because I've heard of some companies doing this, na they hire employees, laging probationary. So tama ka, yung 555 scheme, meaning 5 months, and then they
let
hire
go.
new workers again na 5 months ulit, when in fact they're performing work that, as Attorney Matula said, are necessary and desirable, meaning it's really in accordance with the nature of their business. So if you're that type of employee na napansin mo 5 months lang lagi yung engagement with you, can you complain to the NLRC about this?
Depende, no? Kung what will be if you're hired on a fixed term, that's legal, that's valid. But if you're terminated on the 3rd month without no reason at all, then you can complain. What else?
So-
5 months you have to have the 13-month pay because irrespective whether you are working for 1 month or 2 months, you have to have the 13-month pay.
Proportionate.
Yeah, proportionately. No,
Even if you're just a probationary employee.
all right. Now, if I may ask this, no, when it comes to getting, I guess, disengaging an employee, whether it's he's a probationary employee or regular employee, this yung provision of the law with regards to due process and just cause, is that still mandatory?
Should apply.
It should apply.
Yeah, with respect to provisionary employee or project employee, the provision on due process shall be followed before the termination of their employment, before the end of the provisionary period or the
So due process still
project.
applies. I mean, in other words,
Meaning they have to have notice and then a chance to be heard, and then notice again on the decision of the employer.
If the employer will decide to terminate the workers, and the grounds that is provided by the grounds that are in the labor code is the just and the authorized causes. It shall also apply to
For instance,
this,
on the probationary employment, one is hired on a probationary basis. At the end of the 6 months, what happens? Can the employer terminate that employee?
just like that.
It cannot be done.
Cannot be done,
Because there are certain conditions. One, for instance, the contract. You have to see the contract. Number
the
two,
criteria.
the performance of the employee, because a probationary period is supposed to make the employee able to learn the skills, the job, and so on and so forth, and able to perform quite well. So you have to have the performance evaluation record for you to legitimately say, sorry,
Sorry, you didn't pass.
If
So
you
if
are
you're
able to show that,
Yes. So if you're a
the
probationary
criteria
employee,
shall
you
be
should
known before the engagement. So
thus
that-
the criteria.
yeah.
So if you're a probationary employee, you have to at least find out if you met the criteria that they told you from the start will be the basis to hire you as
So
a
again,
regular.
that's why they came up with this scheme of fixed term. At the end of the 6 months, you don't have to explain. Kick him out.
Oo, pag fixed-term
fixed term,
employment.
fixed term,
Pag sinabing probationary employee, then
Probationary
they
din,
ano, have to
oo.
justify why they're not hiring you as well.
Okay,
They have
yan,
to
yan.
explain to
Sa
you.
mga employers dyan, so just because the term you're using is probationary, doesn't give you the right, no, the outright right to just kick him out just because
After
it's probationary,
the-
just
yes,
because
after the
probationary
6
siya.
months, for
Okay, I want to clarify kasi most employers think that just because
6 months?
probationary, any cause, parang because I want to get rid of that person, I don't like his face, I can get rid of him. So dapat just cause pa rin and due process. All right. Now, beyond that, but now, just to clarify, yung mga probationary employees, are they required to have those benefits you mentioned? SSS, PhilHealth?
Of course, that is
first
mandatory
day.
as long as there is an employee-employer relationship.
All right.
So the law required that the employer shall remit to the social security system to the PhilHealth and Pag-ibig the required contributions. Of course, that is a shared contribution. The employers has a contribution
And employee
the
as well.
employees as well.
All right. Okay, we have some questions, sir. So this question is from Kiko. I work for a real estate company for more than a year now, and up to now, I still don't have any contract with them when I'm supposed to be a regular after 6 months. What legal actions can I take against them? Am I entitled to bonuses and 13th month pay, even if I haven't signed a contract with them yet?
Okay. So this is already
Yes.
about a year.
That's the written contract is not required when you work for more than a year, and you have been working now. You are entitled to 13th month pay and all those benefits because you are considered as a regular employee now.
Yeah.
And then if they will not make you a regular employee, probably you can write to the HR that to call their attention that you have been working for 1 year and you should be considered a regular employee.
And if you're not given a regular
If you
position,
are not given, then you can go to the regional arbitration branch of the National Labor Relations Commission, and the labor arbiter has jurisdiction over these kind of cases.
and just to clarify, Attorney Sani, they don't need a lawyer at this point, right? They can go there and merong standard forms naman.
Yeah, that's
to fill
true.
out.
The Department of Labor has adopted what you call the single entry, that before you file the formal complaint, the Department of Labor should facilitate some sort of a conciliation and mediation. That the parties will be called together and be given a chance to settle the dispute before filing a formal complaint. And
Okay.
it's very successful.
I
Yes,
want to
Dave?
make a quick follow-up. The question was about he doesn't have a work contract. He doesn't have to worry. He doesn't have to worry if he doesn't have any work contract because that is the responsibility of the employer. Continue working, and the benefits that should be given to you, even if you don't have a contract.
Should be continued.
Should be good. So the 13th month
The
pay
13th
that
month
he was
pay.
asking about before, if it was not paid to him for the first year that he's been working, he can claim
You
it.
can claim that.
Yeah.
Okay, to
As a-
Kiko, so we can
Even if he
rest.
doesn't have a contract,
Yeah, we can assure
Yeah.
Kiko that Kiko,
He
you
can-
are
he
a
can-
regular employee already, even without that contract. All right.
Our next question is from Patrick. Does my employer have a right to force us to render overtime? We will be launching a new program and they are making us do overtime for 3 hours on Fridays and Saturdays. If we fail to do this, we will be reprimanded by our team leader. Do the employees have the right to refuse? So, kahit Saturday, and then
Weekend.
3 hours.
3 hours overtime,
yes.
3 hours
Oo,
overtime.
And are they allowed to refuse?
before the lawyer answers. The statement says that can an employer force an employee to work overtime?
Yes.
Yes. Then the second point is, can an employee refuse to work overtime? Yes.
Okay.
So it would depend now, no? If there is a reason for the employer to get his employees to work overtime, certain targets has to be met, export quotas to be met.
Yeah.
I think it would be good for the employee to work as demanded by the
An
employer.
employer. Okay.
The only time that an employer can force an employee to work during crisis situations, there is flooding, there is fire, there is emergency in lang.
So pag may mga disasters.
Disasters, pwede yun.
All right. Now from Twitter user @BernieMac10, what are the unfair labor practices I should be aware of? I just graduated and have already secured a job in a BPO company, but I also want to know the nature of these offenses. Should they be committed by my present employer?
Wow. Preventive siya.
Unfair labor practices.
Okay.
The concept of Unfair Labor Practice Act is connected with the right to self-organization.
Meaning yung having a union.
Yeah, organizing
collective
a
bargaining
union or
agreement.
association, for example.
Okay.
Right to negotiate.
If the employer will interfere on your organizing work, then that is Unfair Labor Practice Act. If the employer will tell you that do not organize a union, that is a clear interference. Or if he will discriminate, like giving you only, for example, 466, but people, because you are organizing a union, the other people were given 500 pesos. So that is discriminatory because of union activities. So that is Unfair Labor Practice Act. So anything
Thank-
to do with interference or harassment or discrimination when you are exercising your right to self-organization, that is an Unfair Labor Practice Act. But not all unfair acts are Unfair Labor Practice
I think that's
Act.
what I was going to say, Attorney Sonny. Thank you for clarifying that because a lot of people, sometimes I hear it from my friends, yung kanina yung situation that we were talking about with one of the questions na 1 year na siya and hindi pa siya binibigyan ng labor contract.
unfair
Others would
labor?
say that's so unfair. That's an unfair labor practice. Or pagka kunwari hindi pantay-pantay yung pay, they would say that's an unfair labor practice. But for the benefit of our viewers, this relates to the right to organize a union, a work union, yung pati yung mga pagka if you get mistreated because you are being prevented to exercise your right
To
to join a
self-organize.
union, to organize.
And,
But
and
there is,
workers can also commit unfair labor practice.
Yeah, the workers themselves.
the workers,
Okay. Maybe we can discuss that.
Later, yes.
But there is some sort of an act which is considered as unfair labor practice, but it seems not related to the right to self-organization when when the employee is testifying on a certain case, on a certain labor dispute, and he is being harassed or being discriminated, that can also be considered as unfair labor practice under Article 248, paragraph E, I think, or D.
So it's very good that we at least enlighten our viewers so they know when to use that specific phrase of unfair labor practice. We'll take a short break for now. Legal Help Desk will return, so stay tuned. You're still tuned in to Legal Help Desk on 9TV with our guests, Dave Diwa and Attorney Sonny Matula.
All right. So we were earlier, right before the break, we were talking. Someone asked about overtime pay, no? And I think that's a little bit of a sensitive issue or topic because for some companies, no, the nature of the work kind of requires a little bit of overtime. Like for me, for example, when I was in a law firm. There was
Same
no such
with
thing.
me.
No such
When
thing as
I worked
overtime pay.
in the
no?
law firm,
Yeah.
basically your work can last
last
from
till-
8
and
a.m.
be knowing,
until 8
Like-
a.m. the next day. So basically
Yeah.
24 hours.
Even-
And yet I do know that I don't get overtime pay.
And advertising agencies, may mga ganun na they work really late or... so, can you enlighten us on that? Are employers of these type of companies where the nature of the job, for example, film industry, when they're producing, diba? For those who are working on TV studios, diba? They work beyond the usual 9 to 5. No? Ano yung basic rule dyan? Can
Take
the
up the
employees
legal-
require or
illegal,
charge overtime pay?
Now, if an employee work for more than 8 hours a day, the law says that the workers or the employee is entitled to
Overtime pay.
an overtime pay. So,
But are there industries, for example, that because of the nature of the work,
Or
let's
not
say,
even
like,
industry.
no, there are
Let's say
some
positions.
exemption. For
mixers,
example, if you are a field worker, the employer cannot monitor your activities because you are in the field, then overtime pay is not required.
And before we move on from leaving that term field worker, perhaps this is something we can clarify. Baka isipin nila yung nagtatrabaho sa field. Basically, what types of jobs? Give examples.
Jobs that are paid on commissions.
Commission. So, for instance, yung
Salesperson,
mga sales.
Sales.
salesperson.
So no overtime pay there.
Then management people don't get paid overtime.
So
Managerial
managerial
employment.
level. And I guess at this point, kasi when I was, when I was working in a law firm, even as a junior associate, wala talaga kami overtime pay. And they were saying because your category is supervisory or managerial position. Even if, obviously, at that point, you're a junior associate, first time mo lang mag-work. But obviously, I'm not managing, but they say that's the supervisory and managerial rank. And maybe this is something we can clarify to our audience. How do you say that you're a managerial or supervisory rank?
Supervisory.
depends on the job. There are certain legal tests to do that. It must be, you call it direct, and there's a legal term for that. That separates the supervisory employee to the managerial, of course, from the rank and file
If you're
employee.
directly supervising people,
Yeah,
ganun, or-
if you are, of course, if you are empowered to hire and to fire, then you are a managerial employee. And you are deciding in a policy making, in
The test.
managerial actions that should be adopted. That is managerial. But if you are only recommending managerial action, then you can be considered as a supervisory, recommendatory. It shall be approved by your higher boss. So that is supervisory.
So basically there are some tests.
That's not a routinary act. But if it is only a routinary act, then you are a rank and file employee.
Okay.
So absence of those given to the supervisory employee and the managerial employee, then you can be considered as a rank and file employee.
Okay, then I'll go back to some benefits. Now that, of course, Christmas season is around the corner, there are people who want to go on vacations. And I guess this is where we can clarify what types of vacation leave benefits are mandatory or are discretionary.
So there are the 5-day service incentive leave is the only mandatory. But
So 5 days. And what are the requirements before you can enjoy 5
at
days?
least you have a 1 year service to the company.
So
So
it can
probably
happen,
less than 1 year, then probably it should be proportionate to your period of service.
So even paid sick leaves are not guaranteed by the labor code.
Yeah, that's not
paid sick leaves.
guaranteed by the labor code. And unless that is under the social security system, but that is another law, not in the labor code, there is a paid sickness benefit, a sickness benefit of 90% of your actual salary. If
Should
you
be sick-
get,
should you be sick.
Yeah.
Okay.
And then there is a maternity benefit, but that is social security again, about 60 days and 70 days in case of cesarean. But there is another new law, but that part of the labor code, the 7-day paternity leave, but that is only for those who have legitimate spouses.
So if
If it's an illegitimate spouse.
for instance, if you're
You're not-
a male worker and the
Wife.
son or the daughter, the baby is with a live-in partner or a girlfriend, you cannot
That's
avail
the problem.
yourself of this
That's the
paternity
problem.
leave.
Yeah, you cannot enjoy this paternity leave if there is no legitimate relationship.
Unfair, no?
On
But
the
they're
other
forcing them
hand,
to get married.
maternity, there's no need of any legal requirement. Either
So you can
Okay.
only have a vacation leave or sick leave outside the ECCS if you have a union and the union is able to negotiate those benefits. in the
So that's why
CBA.
we are urging workers to organize so that they could negotiate
I see.
with other benefits
I
other than those legally
Or I
provided.
suppose check with your company because if this is already a company
Yeah, if there is
practice
a
that
company
they allow,
practice.
There are.
for instance, 7 days vacation leave per
It's already a
year.
practice.
More
then-
than that, in the companies that we are the collective bargaining agents, 15 days vacation leave, 15 days sick leave benefit, and if you will not avail that, it can be monetized at the end of the year. So that's in addition, but
In
that's
addition.
not mandatory.
That's mandatory. All right.
It will become mandatory if it is already company practice or a part of the collective bargaining agreement.
All right. Okay. So we still have some questions from our viewers. From Gordon. I am a team leader working for a small BPO company. I was put on floating status. I would want to know if it is legal not to be paid. I was never paid during this time and I was on float. I returned to work on October 2014, but I'm now on floating status again with no pay. Floating without pay. I completely understand that the company has losses, but they are still in operations. I just want it to be fair. Should I at least be compensated while I am on floating status? Do you think I have a case here? So what is there a legal term?
If the float is not the fault of the employer, then the principle of no work, no pay will prevail. So
We say no fault of
But
the
in this
employer.
case,
no fault
it
of the
seems
employer. There's no work, so what can we do? So,
But is that possible here that it sounds like he's been working with the company for a long time.
Okay.
So if he's suddenly put on floating status,
Yeah,
basta-basta
usually
na lang,
the
does the
float-
employer have to get the consent of the Department of Labor first before he puts this employee on floating status?
Usually, if there is no work for a long period of time, they should inform the Department of Labor. For example, there is a suspension of operation, and there is the company cannot provide work, then they should report to the Department of Labor.
Before they make any changes.
Yes.
Dave,
But,
in this
yeah.
case, parang may cycle na in-on, off, on-off. Is that allowed?
Putting workers on a floating status is valid, legal.
It's legal.
Okay, but you cannot put them. But there should be some reasons, some reasons, some justifiable.
What are those valid
causes.
reasons?
This usually happens on security guards. No, there is no deployment available, so you're placed on a floating status until the next contract comes in.
Okay.
So that's allowed, but you cannot put an employee under floating status for more than 6 months. After that, you'll have to find job for him, or you pay him,
Even if they're not
Separation
working.
even if they're not working.
But if a worker is already regular, can you put him in floating
That's why
status?
the question comes from from a BPO company,
Team leader, yeah.
and he's a team leader.
Yeah.
No? So I would suppose that his account must have been closed, and the company is waiting for a new account to come in.
yeah.
So he was placed on a floating status. Then after a while, he was rehired, maybe for 2 or 3 weeks. Then he was again put on
Yeah.
a floating status. Yeah, the entire floating period should not exceed 6 months. Then he was asking, "Can I have the case?" Definitely.
A case
And if
for
he
what?
paid-
A case for what?
It could be construed as
Constructive
constructive
dismissal.
dismissal.
So he can go to the National Labor Relations
Yes,
Commission.
Beyond
I think
cumulative
it's-
6 months.
Beyond 6 months,
Cumulative
so-
of 6 months. Kasi let's say na-floating siya ng 1, and then na-float siya ng 2.
Okay lang.
And then so if it accumulates to a
More
total
than
of 6
6
months, then he has a
na.
case of constructive dismissal. Okay.
Okay, I think he should go to the NLRC and find out if this is something that he can file against his employer. Our next question is from Lizelle. My husband was hired as a project employee in a construction firm. He was given 3 continuous contracts. He was hired last July 2013, but then their HR gave him a termination notice until May 2014, even if the project is still ongoing. He was being terminated on the grounds that he was not able to have some documents signed by their HRD manager. Isn't my husband entitled to a so-called due process? He was not even asked to explain his side. I want him to file a case against his employer. And what chances does he have on this?
Lawyer.
So he was terminated before the end of his contract because of some clerical requirements.
Requirements, yeah.
So I think he has a ground to file an illegal dismissal case because he is protected by the right to security of tenure during the term of his contract. So an illegal dismissal case can prosper in this kind of situation.
We have another question from Marcus. Is salary downgrading legal? I've been working for this company for 1 year and 4 months. I was offered a good salary when I was hired, but then the company decided to lower the rate of their employees. The salary is now only 33% of the original salary offered. Many of my colleagues resigned because of this, and I am thinking I should do too. Can they do this under the labor code? Ang laking difference, no? 33% na lang yung
33%, so
natira.
that is a diminution of benefits
Diminution
or
of
salary, which is prohibited or prescribed by the principle under the labor code, that no diminution of benefits.
But let's say there are losses. There are losses in the
If
company.
you're an employer naman at ikaw yung nalulugi sa
Nalulugi ka,
business,
yeah.
how can you suddenly decrease the rates of your
You can
employee
adopt other
salary?
measures other than that, other than diminishing the
benefits of the
wages, particularly that's a wage benefit. You can be charged of constructive dismissal because of the diminution of the wages or the decrease. So very substantial decrease
Yeah.
of.
So what are the options of the employer there? What are
The option of the employer, if he is losing, then some saving measures like cutting the perks of the managerial employee. For example, if they're given a car, then you have to stop muna the car privilege.
So you have to protect the rank and file.
Yeah, you have to
But also, if for instance, in good faith, you're an employer talaga na nalulugi, but you want to keep your employees instead of firing them, you can still reduce the salaries if you agree with them, meaning may consent ng mga employees. Is that possible?
If that is there is a consent probably with the employees, then the employer will not have a problem. The problem is if the workers will file a complaint, because that will be really can be considered as a constructive dismissal. 33%.
Yeah, so dapat talaga get the agreement of your employees
Yes,
first.
Yes.
Okay. Thank you so much, Attorney Sonny and Dave, for all your helpful inputs. And very interesting topic again, and I'm sure very enlightening to all the workers.
We should
out
really
there.
have a part 2 of this.
Yes,
This is,
definitely.
I mean, when it comes to employees,
This
of
is
course,
my
we always-
second time.
Yeah, we have a lot of people out there who are watching, and obviously they have a lot of questions with regard to the terms of their employment. But thank you, and we'll call you again for
Yeah, thank
for
you.
future topics.
future topics, yes.
It's a very wide topic
Yes.
talaga yung labor.
Yeah.
Legal Help Desk will return after this short break. Welcome back to Legal Help Desk on 9TV. And tonight our topic was relevant to not only employees but also for employers.
Yeah, it's applicable to me because I'm both an employer and an employee. So I was listening to all what they were saying, no, si Dave and Attorney Sonny, and I think it's important to know, no, if you're starting a business, what you're gonna give the basic benefits under the law, no? Kasi obviously the moment you don't give those benefits, could be subject to penalties, right?
Yes. And also this is very relevant for employees out there, especially those who are looking for jobs, because one, when you're looking at the positions, if you're choosing among different companies to work for, then find out what they're offering you. Don't be ashamed to ask what's on the table, because that's usually the big mistake of others, diba? They just sign an employment contract and then later on they'll find out, ay, ito lang pala yung salary, ito lang pala yung benefits. Because again, what we learned today is that there are some mandatory benefits, including, of course, minimum wage. But you can get higher wages depending on what is offered to you and what you agree to. And then there are also other benefits like some companies give meal allowances, transportation allowances, even rice allowance, laundry allowance.
Yeah.
But these are allowances that are not mandatory. So some of your friends might be enjoying these benefits, and if you want to have those benefits, then look for a company or an employer that will offer that to you. And again, yung mga vacation leaves and sick leaves, these are also not mandatory. What's mandatory is a 5-day service incentive leave, which can be given to you after you've worked for at least 12 months. So again, this is not automatic, but some employers do have, as a matter of practice, vacation leaves, for instance, like 15 days per year. So if that's what you want, then look for an employer that will give that to you.
Yeah, okay. So yung magic number pala for our employees out there, no? Magic number is 466. Yeah, 466
If you're
pesos
in
per
the
day.
National Capital Region.
If you are in the National Capital Region, 466 pesos per day. Now, we wish we could give you kind of a basic rule on whether that, if you only work for 3 days a week or 2 days a week, there's no real basic rule, no. But the usual requirement of the labor code is that a work day is 8 hours a day. No, 8 hours a day, and then 5 days, the work week is 5 days a week. So if you do the computation, do the math, it's roughly between 12,000 to 13,000 a month dapat na minimum wage that you should be getting. No?
And since you went into hours of work na, overtime pay, let's clarify this. Generally, employees are entitled to overtime pay if you work beyond 8 hours. But be careful as well when you say yes to a job. Find out if you're considered a supervisory or managerial rank position, because this is different from the rank and file employees. Sa ilalim ng batas natin or under the law, it's those rank and file employees that are entitled to overtime pay. If you're considered supervisory or managerial position, then you can't really get overtime pay even if you work, for instance, 12 hours or over 24 hours. And if you're a field employee, meaning, for instance, yung mga sales and marketing position where you earn on a commission basis, even if you work more than 8 hours, you're not entitled to overtime pay. So these are things that you should clarify before you take on a job, so that you know what you're getting into.
Right. Okay. And then finally, above the wages, you have PhilHealth contribution, Pag-ibig, and SSS. So for employers, no, you have to remember you have to be contributing to these. Otherwise, you'll be subject to penalties. Employees, you can demand for those benefits.
Yan ang mga mandatory
mandatory
benefits.
yan. All right. Over the week, we have received questions from our viewers on topics we have discussed. And Leilani asked us, I am divorced. I have with me the original divorce papers and had it translated from Nipongo to English. Do I need to file a petition in court for my divorce to be recognized in the Philippines? Is there another way for the dissolution of my marriage to be recognized here?
Okay. So it seems like the divorce was obtained in Japan.
Yes.
But just to clarify, the divorce should have been obtained by your foreign spouse.
Right.
Because under our law, if the foreign spouse of a Filipino obtains divorce abroad in a country where divorce is recognized, then all you have to do is have that divorce recognized in the Philippines as a ground for having the marriage declared null. And but if it is you, that the Filipino spouse here that obtained the divorce abroad, then you cannot have that recognized here. Because
Unless,
it
of
would
course,
be a ground.
Lailani is already a Japanese
A
citizen.
Japanese,
right?
yes. Or a dual citizen, yes.
Dual citizen ka na, no?
Pwede
so,
rin yun.
Pwede na. I guess it'll be recognized already. Okay? So, but if you remain Filipino, then what Attorney Karen mentioned applies, no? It should be your Japanese husband who
whoever
obtained,
is the foreign spouse should
who
obtain
obtained
the
the divorce. All right.
Our next recap question is from Kay. My dad left us 17 years ago, and during that time, he did not give any financial support. I wasn't able to finish my studies due to financial problems. I am now 24 years old, and can I still file a case against him and ask for financial support in all the years he failed to do so?
Well,
So
that's
delayed claim.
Medyo delayed claim, no? I guess that's a little tough, no? Not at this particular time. I guess it would also depend if she's already employed, gainfully employed. I don't know if you can. That's actually an
Because
interesting
custody
question.
is actually needs-based.
Yeah.
Sorry, not custody. Financial support is actually needs-based. So at the time that kailangan niya, she should have claimed for
should have claimed
support.
that time.
Although yung support naman, it has a prescriptive period. So what she has to check is kailan ba yung claim na yon? When did
17
her
years,
need for support arise, and kailan siya magpa-file?
Yeah, so
Usually
the
10
dad
years.
had left 17 years ago. So she was 7 years old at the time.
And now
But
she's
I think,
already
I mean, from we have to review prescriptive periods, no? But I think it has
10
already
years.
lapsed and you're already of age. I think at that time you had a case or your mother had a case at the time that he had left. But now that you're 24 years old, it might be a little bit of a challenge. I think the court would probably kind of question that.
The claim might have already
It would depend on the
prescribed,
facts, of course, of the case. All right. Our last question is from James. I wish to take custody of my child since he is illegitimate. I'm aware that custody automatically goes to the mother. However, this mother is not taking good care of him. He's always sick with fever, colds, cough, scabs, and diarrhea. There are also signs of abuse. I've seen his bruises and even a burn mark from a flat iron. There was also an incident when he was nearly run over by a car because nobody was looking out for him. What can I do to get custody of my son?
Wow, it sounds like the son is with a negligent mother.
mom, no?
Yes, well, actually, in this case, there is really a presumption, especially if a child is under 7, that the best interest of the child would be with the mother. And especially if you're talking about an illegitimate child, the custody is with the mother because it is the biological mother that has parental authority over the child. But in cases like this where there is negligence and neglect and abuse especially, then
Criminal,
obviously the best interest of the child is not to be with the mother, and in this case, I think you have a very good chance of getting the custody of your biological son.
There's a possible criminal case here, obviously with the injuries being sustained. No?
Yes.
But everything is
It
evidentiary.
is.
It will be based on the evidence that you have. No? A possible option you can have is probably go to the DSWD as well.
And, and he can, I think, in this case, file a case for child abuse because of the neglect and also signs of physical abuse.
All right. All right, so that's all the time that we have for tonight. We'd like to thank our viewers who send us questions every week via social media. I'm Rod Nepomuceno.
And I'm Attorney Karen Jimeno. If you have any questions about our topic for tonight, you may post these on our Facebook and Twitter pages. Join us again next Monday as we discuss your legal rights. Good night.
That's it.